So from there, let me come to the question of privacy and surveillance. Because the aftermath of September 11th has been one where, as Americans, we've all mourned for the loss of 3,000 innocent lives and the horrific attack that happened on the United States. But we also saw a set of policies of the U.S. government that were targeted at suspected terrorists, and these are the ones that I just spoke about. But we've also seen a much widening, a much bigger net that's been cast on information about all Americans and their ordinary daily activities, which is a new level of surveillance state. And in this post-9/11 era, not only is it the fact of 9/11 that has given this extra energy, but it's also all the new technologies, all the new information technologies that have given it a whole new dimension that may not have been there in a previous decade. The surveillance issues and the privacy issues that we're working with, especially at the ACLU of Northern California, are really looking at the role of the internet. Every time we go on the internet, we leave a trail of information that's available not only to the people whose website we visited, but that information then is bundled and sold to companies that market and target products to us, but that also can be sold and provided to the government. I'm wondering how many people here use Facebook or use a search engine like Google. Have a phone with a global positioning system. So these are all daily tools that we use, and we're voluntarily providing a lot of our information into this. But then that information is available both through these data mining companies that can aggregate and buy vast amounts of data, but also can be available to law enforcement, whether local or federal, maybe simply with a letter or a subpoena, but not with a warrant that's been approved by a judge. And this is a whole area of the law now that is completely open. It's an area that we're working on both through litigation, but also through legislation. The federal law, called the Electronic Communications Privacy Act, which governs this, was last updated in 1986, before there really truly was even an internet. And so we're working on updating that federal legislation, which used to cover like cassette tapes, and make it apply to this new era in which all of our information is in the cloud. So that's an area where you can count on the ACLU working hard. It's a federal issue, and so that's where our collaboration with the national office and with the affiliates throughout the country is so important. But it's also a Northern California issue because these companies are predominantly based in Silicon Valley, so we're providing a leadership role on this issue to the ACLU throughout the country. Let's now turn our attention to a little bit more directly to California. And there was the question about Prop 14 and just the state of our democracy here in this state. Prop 14 sets up a system through which the top 2 vote getters in the primary go on to the general election, and so then you have a choice of 2 voters in the general election. The ACLU opposed this in the earlier stage before the votes were cast, and now we are in contact with attorneys who are going to be suing on the grounds that this the law has several problems, but I think the one that concerns us the most is the way in which it harms the freedom of assembly and the freedom of association for political parties. If you're not in the top 2, then you don't have a chance to have your candidate be before the voters in the general election. In a strange way that the bill was written, the ballot measure was written, it doesn't even give voters a true chance of writing in a candidate. Or it permits you to write it in, but then they won't count it, as I understand it. So we will be challenging that. But I think that overall, there's a sense in our state that things are in crisis. I think whether it's the way that the election system is happening or the fact that we're at a record delay in the state budget, We're all frustrated by the way in which our state is being governed and run. I think, to me, one of the most troubling aspects of how our state government works today is the priorities in the budget. One of the issues on which we're very active is the death penalty, where the state spends over $100 million a year to keep almost 800 people on death row and to pay for their appeals process, when if all we did was change that to life in prison without the possibility of parole for people who are currently getting the death penalty, we would be able to divert literally tens, if not over $100 million a year to prosecute unsolved crimes, to provide services to victims of crime, or to invest in education and other worthy priorities. Our legislative office, which is in Sacramento as well as the chapter here, has put a great deal of energy into the state budget process and state legislative process. We've had one very good outcome, a bill that reduces it changes the petty theft to grand theft level and adjusts it for inflation, so that what might before have been petty theft will now stay as petty theft, and some of the crimes that are on that borderline between petty and grand theft will now be petty theft, adjusting it for inflation. You cannot imagine the number of hours of dedicated time it's taken our lobbyists to achieve even such an incremental change that saves the state, I believe, over $70 million a year. But more significant criminal justice reforms were all stopped earlier in the legislative process. So it's going to take a lot of work by our members and our chapters, our allies, and our legislative office to be able to get this state's priorities correct when we're spending really unnecessary dollars to put people behind bars for crimes that do not deserve such harsh sentences, when we're laying off school teachers and taking away financial aid from college students and turning away tens of thousands of students from our community colleges and our universities. Now, of the topics that you all raised, the one that I have nothing that I can say to that's useful is the issue that you raised about small claims court. So afterwards, I'd be happy to learn, and you should feel free to contact me after, and I'd be happy to learn what that issue is. But maybe others in our office work on it that I'm not knowledgeable. So this is a little bit of a walk through the ACLU. We have in California a great deal of work that your membership dues support. But more importantly, we have in California a great deal of work that's strengthened by your active participation in the ACLU. Whether that's when you write a letter to your state legislator, or when you attend your city council meetings, when you monitor your local police department or school districts. We really benefit from your participation in all of those ways. And I want to thank you for being a part of this great organization that we all support. Let me pause there, and I'll see, depending on how much time there is, what kind of additional questions I have.
As much as you're willing to allow. Speak to that.
Let me go to you. Yes.
When you presented the information on both the petty theft, grand theft, kind of the wobblers, as well as the death penalty, I was left with the impression that your paramount argument had to do with cost savings, and I hope that while that would be included in the whole argument, I hope that you're not presenting that as the paramount ACLU argument just to save money.
That's a great point. There are, for each of these different criminal justice issues, there are a set of unique arguments that we make depending on the circumstances. But I do have to say that the cost issue is significant, especially right now during these budget crisis period that we're in. But we're not limiting our arguments to that. I do have to say, as we work with our partners in the death penalty movement, that traditionally the movement against the death penalty, for example, has been grounded in just a few key principles. One is the idea of the cruel and unusual punishment to inflict death. The second is the fact that government can make mistakes, and we don't have a judicial system or a criminal justice system that is free of mistake. And so if we take a life, we can't ever go back and correct that. But it's new for our movement to make the cost argument on the death penalty, and we find that it works well, and we do really try to see people to think about the trade-offs. On the ballot, there's the ballot measure that legalizes taxes and regulates marijuana. And there we see not only the importance of the due process issue of people who are put in jail for possession of a small amount of marijuana, but the cost argument certainly also adds strength to that issue.
On the subject of marijuana, if my downstairs neighbor decides to get drunk, that's not going to make me drunk. If my downstairs neighbor, however, decides to smoke marijuana, that's going to end up making me high because, the air is not isolated from each other. So what about that issue? I've never heard that mentioned before.
Well, that's a secondhand smoke issue. So I believe the law is written in such a way that addresses that. But I think for all of these substances, whether it's alcohol or marijuana, they have an effect both on the person who uses it and then potentially on others. But I think our view is that marijuana is better treated on the whole, closer to how we deal with alcohol. Alcohol is a drug. It is addictive, and yet we don't criminalize it. And the last time we did, it was a big mistake in this country. So our view is that marijuana should be more closely treated the way we deal with alcohol than compared to some of the other substances.
I'm curious, what can we do about the 3 strikes law?
What can we do about it?
Yeah.
The question was, what can we do about the 3 strikes law? There are 2 things we can and have to do about the 3 strikes law. The first is that we need to reform the law as a statewide policy. And there have been ballot measures to do that, and it will ultimately require going back to the voters in order to make the changes needed to the 3 strikes law. In particular, under the current system, if the 3rd strike can be a very small issue that can lead to a 25-year to life sentence. And so the most viable proposals would be things that would require the 3rd strike to also be violent. I think the other issue that's going to kick in over time is that we're going to have large numbers of geriatric patients in state prison at a great cost to taxpayers when they pose truly zero threat to the public. So I think that bill is going to come due in our generation, and it's just not a sustainable or smart way to allocate scarce public safety dollars, to pay for the highest security nursing home you could imagine. But there's a local answer too, which is right here in your county. Each prosecutor, each district attorney has enormous discretion of what crimes that they pursue and what punishments they seek. And so your district attorney can choose to use our scarce tax dollars to go after and get death penalty or 3rd strikes convictions, or they can choose for each of those another option, like the life without parole for the death penalty, or another option on the 3 strikes path. So I would just encourage your chapter to engage with your local district attorney to make sure that they're prosecuting with public safety in mind, with the due process issues in mind, and with our scarce tax dollars in mind. So you have that path available.